Yes, I guess in my experience, so we produced a will 20 odd years ago when my kids were little, outlining what we wanted to have happen and who was going to care for them, that sort of thing. They're grown up now, they've left home. We've invested in lots of properties and we have businesses now. So I guess we really need to think about updating. And I know I should and I haven't. And I think, I believe it's a big problem for the business if I was to die.
Yeah. Or even if you weren't to die, but you were to become ill.
Yes.
Become ill.
Mm-hmm.
And that makes it a big problem too.
Yeah, because the business would potentially stop trading until all those bank accounts would be frozen until, so it's on my to-do list.
So I heard that. So what is it? If you become ill, you become unconscious, and they can have a ruling, or the doctors sort of inform the right people, and then they freeze your accounts. Is that correct?
Yeah. So if they do something called a dole's notice. It's the deprivation of liberties, which sounds a bit draconian, I think, but they report your mind or non-mind, shall we say, to the court protection, who will then protect your assets for you, which means freezing everything.
Yeah,
freezing everything and letting it all fall apart.
It doesn't do anything to protect your assets. It just stops other people spending them and letting it fall apart. Yeah.
Right.
So what happens there then? So is that a joint thing? So is that a will and a power of attorney, for instance?
A will is not effective until you are dead. You can't take any action on anything until somebody has died. So until you've got your death, in fact, until you've got your death certificate in your hand, you're really not in power. Your will is not set in stone. That's the moment it gets set in stone. Well, not quite, but I won't go there. So you should also have a lasting power of attorney. So that's there are two of those. There's the property and affairs and a health and welfare. I'm sadly old enough to remember when we only had one, which was called an enduring power of attorney, and it only covered property and affairs, what the property and affairs covers. Now, the health and welfare, when it first was invented, or first enacted, the RET Act was enacted, was probably about, I think it's about 15 years ago now. I still think of them as new, but that's an unfortunate side effect of being in the legal profession. You think things are new all the time because they aren't like they were when you started. And we sort of told everybody, they don't need a health and welfare one, it'll be fine. But as doctors have got younger, they have little boys as doctors now and things, they are more keen on you having had a power of both parts, health and welfare. And they are certainly at that point
Oh, I think
sound went.
They shouldn't do. Sorry, somebody tried to phone. That they shouldn't do. So I think that is certainly a way of thinking. With your powers of attorney, you should do both parts now. Register them. There used to be a school of thought that said, just do them and register them later when you need them. Registration period at the moment is 20 weeks. And my opinion is, but so I think probably they're better done, registered, put in a drawer, and wait till later. That gives people to give the power to withdraw treatment should you think they want it. And if you have also become of unsound mind, then that person can give. So we think more of dementia, but there can be all sorts of things, you know, there's early onset stuff, God forbid, but there's also, you know, young people having strokes, having accidents that have damaged their brain in some way, so they then get put it within the court protection, and so it's useful to have that document and review it on a fairly regular basis, because it's no good if they're all dead.
Go on. And what about, you know, so thinking about, so we've looked at will. So the will obviously kicks in when you've died. You've got the power of attorney in case you become incompetent or you're very ill or whatever from that side. And how does that compare? So obviously we're talking from a property perspective here, and we're all perhaps doing joint ventures or doing having a business partner and things like that. So obviously I've got a business partner, and we've got quite a detailed partnership agreement, so to speak. So is there kind of a hierarchy that goes down? So if I was to suddenly the shareholder agreement will rule for the business assets. So that would always be the case. So but only the business assets. So somebody can't come along with your power of attorney and go, I don't want that to exist anymore. So that will always have for that. But for the rest of your life, the powers of attorney are more applicable. I like to think that in a shareholder agreement, there's something that happens when you're dead. But that isn't always the case, because people don't like talking about it. But there should be something, because you could end up with unwittingly with a business partner that you really don't want. Yeah, like the other person's partner or something like that. Yeah. And what do you think of kind of the there are insurances, aren't there? So you can have a sort of you can have things in place, and then there's, I know the one that we're keen on is the one where if one of us dies, neither of us, no disrespect, we really like the other person's partner, but we, as we said, we went into business with each other. So if anything were to happen at that stage, it's having an insurance that buys the other person out, so to speak.
Yes, yeah. And to be fair, that's probably the best way to do it, because it would be more, the other person is going to be really hurting if their partner's died. Not that you aren't, but they're probably not in any they're not capable of coming into the business and doing anything, even if that was their thing. They're still not capable of it. I think is a lot. It's like picking up a story halfway through, isn't it? You can't, you haven't got all the nuances in that maybe you need. So but that insurance should not be in the benefit of the estate of the deceased. So you should be in your case, you should be insured to get your business partner's proceeds, and the agreement should be in the shareholder agreement. And if it's a limited company, it could equally be the limited company can be the beneficiary of the insurance. But what you don't want is the deceased person being the benefit of the insurance, because it goes into their estate and is therefore inheritance tax is payable. So you want it to pass outside their estate.
Okay, and this kind of, I suppose, goes into what advice would you give, somebody who is, so let's say, for instance, like Wendy, so obviously she did a will a while ago now, and then needs to come back to it. And there's now so many things. I mean, you've spoken about a lot of stuff, which is quite a bit of jargon. What would you advise? Who should we go and look to? And then obviously the fact that we're in property as well. I know that we've had conversations, and then I've gone and spoken to a chap that I know that does wills, and there's a bit of conflicting information, because obviously they come from it from a generalist, and we come from it from a very much a specialist. So what kind of advice would you give people, going off and looking to either do a will or redo a will? Who should they speak to, and should they be property professionals? I do wills, but I can't do everybody's in properties will. But it would,
I'm more than happy to talk to people and set up somebody else to do their will. So I'm happy to do it on a consultancy basis if they've got a lawyer and they want to understand how it's more applicable to their property. But you've got to look at the whole person, and I really think that it's not fair that some people go, well, what do you want? Just do it, because you need to get to know the person very well and ask them questions that you probably think, I don't want to know that. I did a will for somebody as a friend's dad as a favour, and he had not talked to me about, I know how many children he has, and he hadn't talked to me about his younger son. And I got to the end of it and I said, what's Brian's date of birth and what's his address? And he said, I ain't leaving him anything. I said, I know you're not. But I knew he was there. So you have to discount that in the will. And some people don't tell you. You know, I stood in, I was working with another couple, and he said, what about kids that are not in your marriage? Something like that. And I sort of laughed and said, if you've got any other kids, you need to come clean now. Laughing, see, thinking this was, and he looked at his wife and he said, how old's that one? And he did have another child outside the family. And had he not have told me, I couldn't discount that. And you only get that by talking to somebody, and often lawyers don't see it like that. I see it more as a holistic approach, because there's no point if I don't know. You know, and I will ask questions like, do you trust your kids? You know, and do you think they're right? And are they the trustworthy ones? And all sorts of things like that. Not because I'm nosy, but because I don't want to give somebody advice that says, oh, just let your children be executors. If you discover they're robbing, thieving, you know, and I can give you examples in my family. I wouldn't dream of letting them be executors. And I will happily tell you who they are. I'm not going to tell you now, but when I'm in a meeting with somebody, I will happily tell you who I wouldn't let be my executor, because I wouldn't trust them as far as I can throw them, because I wouldn't think they'd do it. And we have to be that honest when we think about it, because otherwise they won't do it.
Goodness.
So Joy, I mean, as someone who has thought a lot about, you know, taking out a will, but hasn't done so yet. I mean, I've got my reasons. Partly is I am single and I don't have kids, so you know, the idea of who I'd leave it to is a bit more complicated. But what would I do? I would book an appointment to come and see you.
Yeah.
To your office, and then
generally do it. I generally do mine on Zoom.
Okay.
I can meet you if you're local. I go and meet you. If you're not, I will do it on Zoom. And then we have a chat. I make some suggestions and send you a form. Now we can do two ways. I can do a report, or I'll just send you a form, say fill it in, and if you send it me back, I'll do your will. I'll open the file and ask you for some money at that point. If you want a report, I'll do a 4 or 5 page report explaining what I think you should do, what you should have, and then that's paid for, and then I'll give you a discount if you decide to go for a will. But no, more than an informal chat is a bit difficult to be doing free. Otherwise, I'd spend all my days doing an informal chat with people. So yeah, you get a diary link, make an appointment with me, and then we go from there. So
and then so what? Then I would need to provide you with information about who all my
I send you the form, because I could sit here taking all that information, but I might as well take it from you. You might as well fill it in, basically, and then I can then take it directly when I start to make sure it gets the spellings done. Although somebody recently, I couldn't read their writing at all, which is not usual for me. But they were unfamiliar names as well. So